State, you have an opening statement on sentencing.
Yes, Your Honor.
Ms. Bird, you may proceed.
It's been a long week for everybody. And I know that there's a tendency for you to want to take a long, deep breath and think to yourself, we're done. We did our work. But you're not done. And we talked about that at the beginning of this jury selection. We talked about that there would be another part to this, and what you would be asked to consider, and what you would be asked to do. And each and every one of you took a note, and you said that you could consider all three forms of punishment, and that you could listen to those aggravating circumstances, and you could listen to the mitigation the defense will put on. The time for that is now. We couldn't tell you at the time what those aggravating circumstances were that we would be relying on. Now we can. First of those is that the murder was committed against a law enforcement officer, Officer Sean Bolton, who was engaged in the performance of official duties, and that the defendant knew or reasonably should have known that such victim was a law enforcement officer. The second, that the defendant was previously convicted of one or more felonies other than the present charge, the statutory elements of which involve the use of violence to the person. And finally, that the murder was committed for the purpose of avoiding, interfering with, or preventing a lawful arrest or prosecution of the defendant. The state submits to you by the proof that was presented during the guilt phase this week, proof that you've already heard, that it's proven to you each and every one of those aggravating circumstances. But you'll hear additional proof during this phase. You'll hear the mitigation proof from the defense. In addition to that, you'll hear proof that we put on in addition about these aggravating circumstances. And you'll also hear what's called victim impact evidence. That's the judge will tell you that's not an aggravating circumstance. You don't consider it like an aggravating circumstance. But the law also says that you don't have to disregard the victim. And so Brian Bolton, Sean Bolton's brother, will come and he'll testify and tell you what his brother meant to him, who his brother was. He'll give you a snapshot. I call him Sean, not out of disrespect, as he was Officer Bolton. But to his family, he was Sean. And to that neighborhood that he served, he was Sean. That's who he was. We'll get a glimpse of that. And while that's not an aggravating circumstance for you to consider, and you don't weigh that testimony will be presented. And you'll hear what kind of impact his loss had on his family. You'll also hear again from Officer Boyd, who was there that night, who rushed to that scene, and who helped bring her aid to Sean. And he'll tell you about Sean as an officer. He'll tell you about the impact that night had on the community of police, and the community of Sean served. You'll also hear from federal probation officers who will tell you that the defendant was on supervised release at the time that he committed this offense, and that he had acknowledged and been informed that he was not to have a weapon, that he was not to use or be around drugs, that he was not to be engaged in any kind of criminal activity or be around people who were. You'll hear that proof as well. And at the end of hearing that testimony, the state submits that it will have proven each one of those aggravating circumstances beyond a reasonable doubt. And after you listen and when that is the mitigation that is presented, the state submits that it will have proven to you that the aggravating circumstances in this case outweigh the mitigation beyond a reasonable doubt. And at that point, we will be asking you to follow the law that you all said that you can follow.